Good morning. Though it was not one of the subject when you undergo underwent your undergraduate in law, simply referring some court fees suit valuation act. But this court fees and suit valuation act plays vital role in every matter. But so far court fees are concerned about criminal side. It is that what practical knowledge would help, but in civil knowledge you should have academic knowledge, the judicial present and what not. So I would like to say, apart from the complicated provisions of the Tamil Nadu Court Fees and Suit Violation is Section 30, suit for possessor not otherwise provided for. That is complicated. Then you see suit for cancellation of degrees, etc. That is Section 40. Apart from that, I would like to refer certain case laws which will help you to get over these problems. The substance of the relief sought for should be considered for court fees, not the form. Then they say some law about fiscal law, that is not important. Then the court can give some more time for paying deficit court fees under section 149 CPs. Then another citation is there that suit filed on original side of High Court transferred to City Civil Court by virtue of exercise of discretion by High Court, no levy of higher court fee. So actually, if you affix court fee before the original side of High Court, the pro rata was somewhat lesser, and if it is transferred to City Civil Court, we have to file 7.5%. But now that has been reduced to 3%. Still, there is possibility of demand of court fee. There you have to refer this judgment MC Rangamna versus State of Madras, and 1959, 1 MLJ 160. So they also said cause of action, and then this. They say major relief and consequential or ancillary relief can be granted on payment of court fee for the major relief alone. Suppose if you file suit for declaration, if you pray for consequential injunction, you need not pay court fee. If you want a separate perpetual injunction, you have to pay court fee. That is what this citation says about that. Then market value. See, normally the market value will be that, but there was no definition of market value either in the Court Fees Act or in the General Classes Act. Therefore, they say for the purpose of market, Land Acquisition Act can be adopted. That was one of the citations. Then they say suit for declaration injunction assessment of mark must be done in accordance with section 7 of the open market value to be considered the revenue assessment. So revenue assessment per year, that is tax, and multiply by 30 times must be the market value. That will be a fair value for the application of court fees. These are our basic knowledge you should. Then another thing is, if there are two different suits, and if for the sake of argument, if you filing written statement for counterclaim in both the suits by both the parties, and for that counterclaim you need not pay court fees. That is also most important judgment. That is same with the set off. Then another thing was, if you have any objection about the undervaluation and insufficient court fee, that should be before the first hearing of the suit. That means before framing issues. That was the extensive interpretation of the Tamil Nadu Court Fees and Suit Valuation Act. Order 14 Rule 2 is the provision to raise an objection under for valuation and the correctness of court fees. Then you see, if the court fee is accepted by the trial court, appellate court should not go into that area. That is 2001 MLJ 315 Rajamal versus Selvi. Thereafter you see, if suppose suit was present to the High Court initially and the same was returned to present subordinate court, if it is accepted as a suit and transferred, then you need not pay higher value. Here, filed, presented, but it has been transferred to subordinate court. Subordinate directed to pay plaintiff to pay the deficit court fee, as the court fee payable is not according to original side rules. So that was the correct proposition of law. I think you understand it. If suit is numbered and transferred, you need not pay fee. If the suit is not numbered and directed to present before the lower court, then you have to pay court fee according to the leviable court fee when if you present the suit before the city civil court or district court. And what is difference between maintenance and annuity is most important. And that time one junior asked that question also. It is settled in Saroja versus Ramai Ammal 85 lawfully 500. There is a main difference between maintenance and annuity is that in the former there is statutory charge created over by the property, and in the latter there is no such charge. That was they say. And some things are there, that is not there. The court should not insist the guideline value of the registration or revenue authorities, because they say there is variable and subject to several question of facts. Therefore, they say that guidelines value should not be insisted for ascertaining the value of the property. Then some refund of court fees are there. Actually, refund of court fee means if the suit is withdrawn, then you are entitled for refund of the court fees. Those areas kindly, I will come later on. I have some other work. Same, and another one important thing I have to share with you, that if you file a letter of administration and one person was appointed on payment of estate duty and court fee, subsequently that person died and you want to appoint some other person to maintain the property, that means you have need not pay court fee. That is also there. Suit is withdrawn, court fee is remanded, appeal is withdrawn, court fees are returned. I will take you later on all this area. Now I have